The coal mining sector has averted strike action after some of the country's largest firms agreed to centralised wage talks. Earlier this year, coal producers said they preferred a decentralised negotiating system, but the idea has been flatly rejected by labour unions.
Coal industry labour unions are expected to submit their wage demands in the next few days. The negotiations are to replace the two-year wage agreement of 2015, which expires at the end of the month. In that agreement, which ended a 10-day strike, the Chamber of Mines and the National Union of Mine Workers agreed that most Category 4 to 8 employees would receive increases. It was spread over a period of time, and workers would receive guaranteed increases of 7.5% in the second year.
The 6 months leeway that we've been given to engage each other to find an amicable solution in terms of going forward, that is where we will robustly engage each other, because for us it is not only about the benefits of our members, but it is also about ensuring the sustainability of the industry.
Mining firms and labour say this year's negotiations will take place centrally under the auspices of the Chamber of Mines. In addition, the parties have agreed to conclude a framework agreement that will govern the wage negotiation process.
Well, it's not looking any better than, significantly better than it was when we negotiated in 2015. We're still operating from a very high cost environment. Exports are still very low. There's been a slight improvement in price, but not so sustainably. So the challenges that we had in 2015 are still with us.
It's also expected that labour and mining companies will discuss a parallel process to conclude company-level recognition agreements at the same time. John Bailey, Pretoria.
Now, earlier this year, various partners reached agreements on ways to improve collective bargaining and minimise strikes. Bowman's employment practice today hosted a seminar to examine these agreements. The firm's Khomotso Makapane is here to tell us more. Khomotso, thank you so much for coming in to talk to us. So this is important that this NEDLAC Social Partners new agreement has been introduced. I want to break it up into the 4 areas you looked at, and let's start off with good faith bargaining.
Yes.
What's the significance of that?
I guess it's almost an attempt to go back to the pre-94 state of affairs, where good faith bargaining was part of the law, and unfair labor practices. It is not done similarly to how it was before, which was enacted by way of legislation, but it is now somehow introduced by way of these agreements. And I guess what is important, which is going to inform all these 4 points, is to understand that this is an agreement that is signed by parties to the at NEDLAC, which will be government, organized labor, business, but it is also important to understand that important role players like NUMSA and AMCU are not signatories to this, and therefore they are not bound by these agreements.
Now, of course, you also looked at industry bargaining councils, and you say the most important point raised was the extension of their administrative agreements. We've heard a couple of unions asking for that. How important are these extensions?
So administrative agreements are essentially what allows bargaining councils to be able to draw fees and from members, and in that way to be able to function, because that is their financial resource. So therefore, without these finances, they are not able to function. So what has happened is, because there's been a pushback against centralized bargaining, some minority unions have succeeded in frustrating the extension of these agreements to non-members. And as a result, then the bargaining council suffers a financial setback. And as a result, it can't function. I mean, some of the bargaining councils, as we speak now, are under administration for that very reason.
And two important points you say raised were strike notices and advisory arbitration in the public interest. What does that mean in layman's terms?
In layman's terms, as it stands currently, in terms of the Labour Relations Act, when strike notices are issued, the union can issue a notice to strike immediately after the CCMA has declared that there is no resolution to the conciliation. But what the accord and the code seems to want to introduce is a process where the union in the private sector will have to wait for 48 hours to allow parties to organize themselves before they can issue the strike notice, and in government to wait for 7 days before they can issue the strike notice. But also what must be contained in such strike notice. Advisory award is just simply a mechanism that the accord and the code tries to achieve, which is to say strike ought to be the last resort. So before people going on strike, all other alternatives to try and avert the strike must be attempted. So therefore, if the parties are not able to reach agreement at conciliation, the CCMA director can appoint an advisory panel, and parties then will participate in an arbitration, in which arbitration then there will be an attempt to try and see if parties can resolve the dispute through arbitration. So if a party does not want to participate in the arbitration, the CCMA director can appoint someone else, a representative, according to the code and the accord, to take part on behalf of that party. But it's also important, I guess, to note that the arbitration process does not deter the strike. So it doesn't mean the strike can't go ahead. It is a parallel process.
All right. Picketing is of great interest to me because you've broken up it into two areas, and I see here you've got the specifics here. So you of course say singing, dancing, etc. are allowed, which we know normally accompany a picket. But you say the code of practice doesn't spell out specifics like what songs or placard messages could be seen to be encouraging violence.
Yes, I guess it would have been a travesty to take singing and dancing from the South African public. I guess we just love dancing and singing. The whole essence, again, is to maintain what a picket ought to be, which is to be a peaceful demonstration where picketers are trying to encourage non-striking employees to join them, or clients of the employer and so forth to join them in a peaceful manner. But we know that the picketing line has been marred with violence, particularly for those long, protracted strikes. So the aim right now is to try and introduce some sort of behavior change and conduct change, and there are these commitments now from the role players that signed the accord to say we are committing to keep the picketing line violence-free and also intimidation-free.
Including the police? Including
the police. And what is important is the police and private security have signed, those who have signed the accord, they are saying, although we don't have a duty to pronounce on the legality of the strike or picketing, but then we understand that it is our job to keep peace and to make sure that there is no crime committed during the picket line.
Very interesting indeed. Let's hope it changes the face of industrial action in this country. Thank you so much for coming in to talk to us. Khomotso Makapane, a partner in the Bowman's employment practice. Sport and weather when afternoon news continues.
Thank you so much.